Hey folks, Eric the Whatever Guy, because it really is whatever with me. And do you folks want to know if a federal judge actually legalized THCA and Delta 8 THC in all 50 states? You guys stick around, man. I'll talk to you guys about that. As you guys know me, my name's Eric. I am the Whatever Guy, and I usually shoot videos a couple days a week, basically keeping you guys updated in the world Delta 8, Delta 9, THCA, just what's going on around. And today, man, sitting here bullshitting around on an early Tuesday morning. As you guys know, we talked about this a few times on this channel. We talked about the advent of the Farm Bill coming forward, and we're really just getting really a lot of confusion going on in the hemp and cannabis space. A lot of the cannabis operators are really pushing down on the hemp space. A lot of the hemp space operators are really just going in different directions. And really, if we're not careful with this new 2023 Farm Bill, we're going to find ourselves in a position where we may all be out of a job. But having said that, we talked about the fact that an Arkansas judge not long ago, not an Arkansas judge, a Supreme Court judge, an appeals court judge, basically for the United States government, looked at a case from Arkansas where these hemp operators were basically fighting the banning of Delta 8 and THC products in the state of Arkansas. Now, the court upheld their opinion, or actually applied an injunction, and what that does is pushes the case off for another year. And basically, even though that has, it has to do with the state of Arkansas, this has broad implications because this is a Supreme Court judge. This is a big judge, a U.S. government judge, and he's basically stating this. And the deal is he gave him an injunction, and it pushes it off for another year. But he never would have given that injunction if they didn't have at least a right to win on the merits. And you're going to see that in this article that we're going to talk about here in a few minutes. Like I said, we talked about this article before, but the guy that is explaining this here today is Rod Kight. And he's going to break this down in a little bit easier way for us to understand. The whole purpose of my channel is to break this news down so you guys can understand. And what you're going to find at the end of this result of this lawsuit, you're going to find out that the judge and those guys making this his ruling are saying the exact same thing. They're saying that a lot of the stuff that's going on in this space is just hard to understand for the normal everyday person to get an idea of what you're trying to do. And when they get into this business, they don't know whether they're doing right or wrong. So we're going to flip over to an article over at I believe this is over at Cannabis Business Law. Okay, and the guy that's talking about this is Rod Kight, and Rod Kight's probably one of the premier lawyers in the hemp and cannabis space, and he's also someone that we talked to when we push forward with our lawsuit here in the state of Alabama on the hemp side for the Alabama Public Health Department. That we're having an argument with them, and then obviously with the medical marijuana in the state of Alabama being so screwed up, Rod Kight's right in the middle of that. He is someone that everybody goes to and looks to get good information, and he's also the one that basically gets these letters and stuff from the DEA. It says a federal court in Arkansas just issued a landmark ruling enjoining enforcement of a recently enacted hemp law. Due to its broad findings, the ruling arguably makes this the single most important hemp case to date, and one that every participant in the hemp industry should read. The order itself only applies to Arkansas law. However, the court's findings have sweeping implications for hemp laws in states across the country. It is not an overstatement to say that every state law that defines hemp differently from federal law or that restricts downstream hemp products based on anything other than their Delta 9 THC concentrations is now in jeopardy of being struck down as unconstitutional. This is an incredible victory for the hemp industry, a powerful vindication of lawful status of hemp products, and an enormous step in the overall progress of cannabis legalization. All right, I'm not going to read this, what he's going to say in his blog post. Basically, he's going to break it down where we can easily understand it. Background and summary. Several hemp companies in Arkansas filed a lawsuit against the state seeking an injunction prohibiting enforcement of Senate Bill 358, enacted on April 11, 2023, which criminalized all hemp products produced as a result of a synthetic chemical process and any other psychoactive substance derived therein. The plaintiffs contend that the act is preempted by federal 2018 Farm Bill, and also that its provisions are unconstitutionally vague and thus void. The court agreed and entered an injunction barring enforcement of the act. This goes back to what I was saying before about being vague and basically not everybody understands exactly what these laws and stuff that they're putting out are. So here's the ruling. In its ruling, the court made three important findings. One, that the act is preempted by federal law under the principle of conflict preemption. Two, that the act is preempted by federal law under the principle of express preemption. And three, that the act is unconstitutionally vague and thus void. I should note that I am being somewhat general about this ruling since this article is not intended to get us bogged down. All right, so we're going to go down here. Conflict preemption. The court found that in 2018, that the 2018 Farm Bill controls the definition of hemp and removes it from the list of controlled substances because the act does precisely the opposite. Federal law preempts it. The court states the 2018 Farm Bill removes hemp from the definition of marijuana in the Controlled Substances Act under the 2018 Farm Bill standards. The only way to distinguish controlled marijuana from legal hemp is the delta-9 THC concentration level. Additionally, this definition extends beyond just the plant to all derivatives, extracts, and cannabinoids. The definition covers downstream products and substances if their delta-9 THC concentration does not exceed the statutory threshold. The court went on to state, defendants contend that the products that at issue here are Schedule 1 substances because they are synthetic. However, the 2018 Farm Bill definition of hemp does not limit its applications to the method of derivatives, extracts, and cannabinoids are produced. Instead, the definition covers all downstream products if they do not cross the 3% delta-9 THC threshold. See, that in and of itself, it basically is a broad statement for them to make, basically stating that all of our stuff downstream is going to be good to go. This finding is important not only because it reiterates the delta-9 THC concentration and sole metric for distinguishing lawful hemp from unlawful marijuana, including a so-called but clearly erroneous distinction on so-called synthetic cannabinoids. Okay, so this is the argument, guys. The argument that the cannabis industry has about the hemp industry is that these concentrations of delta-8 and THCa and stuff like that are found in such minute amounts in the hemp plant that they have to extract it. But it's not cost effective for them to extract it. So what they've been doing is they have been extracting the CBD from the plant and then converting that CBD over to the product that they want in-house, like in a lab. They could convert it over to delta-8 because all those products are inside that full spectrum CBD when they pull it out. And what they're doing is converting the rest of it over to delta-8 or delta-9 or whatever else they want to do. Two, the court states the anti-preemption language defendants cite specifically references more stringent in-state regulation only as to the production of hemp, which means that Arkansas may continue to enforce laws regarding the growing of hemp within its borders, but not its interstate transportation. The 2018 Farm Bill clearly provides that states may not pass laws that interfere with the right to transport hemp in interstate commerce, including hemp derivatives like plaintiffs' products at issue here. Okay, so basically what they're saying here is basically interstate commerce. So even if Arkansas says, okay, you can't have these products in the state, they cannot allow them or stop them from moving through the state. So if someone in the state was buying or they had to travel across that state with the delta-8 products, it would not be illegal. That's basically what this is covering here. And then, of course, the third thing is void for vagueness. The court states the due process clause dooms certain laws that are too vague. A law crosses that threshold when it either forbids or requires the doing of an act in terms so vague that men of common intelligence must necessarily guess at its meaning and differ to its application. Act 629 contains terms that would confuse even an exceptionally intelligent reader. Specifically, continuous transportation, synthetic substance, and psychoactive substances are vague and are not defined in the statute. Additionally, Section 10 of Act 629 provides that a hemp-derived product shall not be combined with or contain any of the following: any amount of tetrahydrocannabinol as to create a danger or misuse, overdose, accidental overconsumption, inaccurate dosage, or other risk to the public. What is a danger of misuse or other risk to the public? How do you quantify an overdose or an inaccurate dosage? These terms are paired with, at best, fuzzy standards and record no explicit statutory definition, making it next to impossible for the typical person to know what to do. If the person guesses wrong, the consequences are potentially criminal punishment. And that's basically what's going on here, guys. We have so much misinformation out here. We have so much of this legal speak going on that really the normal everyday person on the ground really has no understanding of what's going on. And we really, when you walk, even I, someone that's in this space, have to walk in some of these places sometimes and wonder if I'm being legal or not. And it's a crazy situation. This judge right here broke this down in such a way that is going to make it easier down the road for us to fight for these hemp products in the state. I appreciate Rod Kight for actually breaking this down and getting this to everything that we're going to do. I'm going to go ahead and read his key takeaways. It says, for the hemp industry in Arkansas, this is an unqualified grand slam. The court enjoined enforcement of the act in its entirety. reopening the state's previously flourishing hemp market. Additionally, and perhaps more importantly, the court's findings have significant implications for hemp laws of every state. Although the court's ruling does not directly affect the laws of other states, it creates a roadmap for attacking state laws that restrict hemp derivatives or hemp products, including THCa, D8, D10, HHC, THCP, and THCa hemp flower on a number of legal grounds. This is welcome news, particularly in the wake of many states enacting laws that unconstitutionally restrict and prohibit hemp products that are clearly lawful under the 2018 Farm Bill. It will be exciting to watch this play out, particularly as we look forward to enactment of the next Farm Bill. Guys, this is a big time win for us, especially in the state of Alabama, where we are actually being poked out by the state health department. This is a crazy situation that we have going on here. I hope everybody appreciates the video. I'm going to go ahead and tell you guys who Rod Kight is. Rod Kight is an international cannabis lawyer. He represents businesses throughout the cannabis industry. Additionally, Rod speaks at cannabis conferences, drafts, and represents legislation to foreign governments, is regularly quoted on Cannabis Matters for the media, and is the editor of Kight on Cannabis Legal Law. He's a big time lawyer in the space, guys. And if you ever want to know or get a legal ruling on what's really going on in the hemp and cannabis space, Rod Kight's the guy you go to. Now, I will tell you this: sometimes he's going to give you some information that you don't want to hear because he does not allow his feelings to get involved in his legal interpretations. But he is extremely smart, extremely good guy to have on your team, and obviously an extremely good guy for me to get content from. All right, folks, this is Whatever Guy signing off, and I'll talk to you guys later, man. Love it. See you.